As a U.S. citizen, you have the right to not testify against yourself in the court of law, and you also have the right not to be subject to an unreasonable search and seizure of your persons or property. And these two rights come from the Fourth and Fifth Amendments. Another significant piece of information is the definition of a search warrant. A search warrant is an order signed by a judge that authorizes police officers to search for specific objects or materials at a definite location. These two things are relevant because the topic that will be explored in this presentation is whether Delawareans' Fourth and Fifth Amendment rights are adequately covered in regards to warrants for the search and seizure of digital information on cell phones and computers. The easiest place to start is the question of why this topic is important. And this topic is important because if police are allowed to have arbitrary and general access to your personal, private, and sensitive information on your devices without any adequate warrant, it represents a breach of privacy and can lead to unjust sentencing. For example, in the case of Lisa Mary Roberts of Portland, Oregon, she was wrongfully imprisoned for 10 years because her cell phone location services placed her near the site of a murder. She was later exonerated due to DNA evidence. However, Lisa's case is not a singularity. And we've seen changes to legislation that reflect some of the worries that are growing about digital information and its use in the courts. In the June 2018 Supreme Court ruling about location services, the court has declared that members of law enforcement will now have to get a warrant in order to request tracking data from cell phone companies. And justly so. Your phone has become one of the most important devices used every day by countless people, not just on a local level, but also on a national and global scale. Studies show that, on average, Americans check their phone 80 times a day and spend up to 2 hours on social media, including Snapchat, Instagram, and Facebook. And as of right now, it is easier for law enforcement to get a warrant to search a digital device than to search a house. And in many cases, the amount and kinds of information stored on a computer or phone are vastly greater than anything you can find in a house or residence. In the past 4 years, we've seen lawmakers start to deal with the issues regarding digital devices like cell phones and computers. However, most of the focus has been on cell phones. In the 2014 Supreme Court ruling, we saw the requirement of a warrant to search the contents of a phone added onto the steps law enforcement have to take. However, from my research, this ruling is inadequate. Instead of granting law enforcement complete access to the data stored on cellular devices, there should be specifications added to the warrants about what is actually allowed to be searched on the phone, especially in relation to the case being solved at the time. By no means should the entire contents of the phone be considered fair game for scrutiny and examination. There is simply too much raw information that can be interpreted or used against the defendant for there to be no additional requirements for the obtaining of such information. In the process of creating this presentation, I've had the honor of interviewing both a high-power lawyer and a long-standing former member of the Delaware State Police Department. And surprisingly, I received similar points of view from both sides of the spectrum on the topic. From my interview with Tommy Wood, the former officer, his response for his thoughts on changing the requirements for a full search of digital data from devices was that it would enable criminals to get off on technicalities and would create more loopholes for defense attorneys to get their clients off. From my interview with Victor Battaglia, the lawyer, his response was that the law is constantly being interpreted on a case-by-case basis, so there is no need to change the laws already in place. And while he did concede that the argument about digital data could be debated, both interviewees shared roughly the same verdict, that there was no need to change anything. In conclusion, from examining the relevant data and reading through several case files, this presentation can conclude with the decision that Delaware and national law does not adequately protect Fourth and Fifth Amendment rights in regards to warrants and digital data, and that a lack of desire to change should not equate to a loss of privacy and an increase of conviction.